Good day, everybody. Immigration issues stemming from the use of marijuana, cannabis. An issue that is very important to discuss because there's a lot of confusion about this issue. We've had some questions in the last few sessions, and we figured we just spend a few minutes to talk about it. So we're going to be spending 15 minutes talking about this issue and then moving on directly and answering your questions. I'm Sam Shihab with Shihab Burke Law Firm. With me is my partner,
Brian Burke, also from that very same firm, conveniently enough.
We are immigration attorneys. We practice employment, immigration, and family immigration law in the U.S. and throughout the world, here out of Dublin, Ohio office, and some remote offices as well. Brian, this topic is an important topic because people come here to the U.S. Do not understand that while you could easily find places to purchase marijuana in stores in your neighborhood, wherever you live, in certain
states,
in 23 states,
yeah.
You could be really shutting down the path for a future in the U.S. as a non-immigrant, as a foreign national, if you do that, and that's a big deal.
Yeah. Well, and let's start by hitting the nail on the head is what we're talking about here. What's the immigration problem here? Basically, in immigration, we talk about issues of inadmissibility and deportability. Deportability is, well, their ability to deport you from the United States. And inadmissibility, it's one of those immigration lawyers' terms of art, but the bottom line, it means whether or not they can admit you to the country, and it is relevant to them at lots of adjudications and lots of anytime you kind of assume that anytime USCIS make a decision about an immigration benefit for you, they're going to be thinking about inadmissibility, whether they could admit you to the United States right now. And the problem is that a conviction or admission relating to marijuana can cause inadmissibility or deportability, and that's really kind of it right there.
So, just to kind of make people understand what we're talking about here and not talk very fancy lawyer talk.
I thought I wasn't, but okay, let's keep
well,
it
no,
going.
It's easy for us to do. If you're using marijuana in the U.S., there is a major problem about you becoming a permanent resident. Simple.
That is simpler.
And there is only one exception in the law, which is if you used 30 grams or less, or is it less than 30 grams?
It's possession of less than 30 grams.
Less than 30 grams. Yeah. So if you had on you less than 30 grams one time for personal use, extremely limited, you may be forgiven, and that's one offense. But 30 grams is nothing. Yeah. I don't use it, but 30 grams by weight. Yeah. It's nothing.
It's paper clips.
And in places and locations where the use of marijuana is legal, 23 states, as a matter of fact, 38 states permit medical use of the marijuana, and also medical use of marijuana is prohibited under federal law. And as a matter of fact, marijuana use is what they call a Class 1 offense,
itself, yeah.
Or a Schedule 1 offense, where the drug is not safe to use even under medical supervision, which is the highest level of classification of any drug in the U.S.
Well, I want to jump in, Sam, and sort of explain the distinction there. So you're saying it's a Schedule 1 drug and it's unsafe to use for even under medical supervision, and that's per federal standards, right?
Yes.
I guess when we hit, but also you just finished saying, well, it's legal in 23 states. You can literally go down to a store around the corner.
And medically in 35 states.
And medically in 35. Is Ohio one of them? I think it is. Yeah. And well, how does that happen? How is it a incredibly dangerous and under the law, but also allowed in?
How is it allowed and not allowed?
Yeah. And that goes to the nature of the federal system of the United States government. There is the national government that sets its own laws. Then underneath that, there are 50 states and some territories as well with their own laws that are subservient but independent in many ways. And this is one issue in which they differ. Whereas federally, they say it is illegal, but in various states in the District of Columbia as well. It is. I don't know. It is.
It
legal.
is legal, yeah.
Yeah.
It's
So
one of the territories
yeah.
or districts.
Yeah.
So, so with that, we need to understand that the distinction between the federal standard and the local standard. And if you are a U.S. citizen, you should have no problem consuming a product in marijuana if you are in a state that allows it within the guidelines of that state because you are a U.S. citizen. Even U.S. citizens could be found guilty under federal law, but there has been a big push to decriminalize it and not prosecute it at many federal jurisdictions and prosecutors. A lot of them are saying we're not going to go after these things at the present time until this issue is resolved. But what is clear is that we do not anticipate that on the federal level that the use of marijuana will be legalized soon.
Yeah.
We don't think that's happening. There's no single president that advocates that, including the current president does not advocate legalizing marijuana, and therefore it will remain illegal and you should stay away from it because it is a controlled substance and it is not legal on the federal level, and it's the feds that give us the green card.
Yeah, that's I guess that's the other point. You know, it's illegal at the federal level, legal at the state level. Well, who cares? Because it's the federal government that is, by the nature of the U.S. Constitution, has the power of immigration. And Sam, you mentioned something. Not a problem for U.S. citizens. I would mention it still is a problem for green card holders as well, because when you are a green card holder, you are subject to immigration problems like related to drugs, inadmissibility, and deportability, like I was talking about. Meaning, just because if you find yourself as a green card holder and find you have an issue in this area, well, you have an issue in this area, an immigration issue, even though you're dealing with the immigration process, kind of.
So if you're a person going through the immigration process, Brian, and you are working for a company, you get a job offer from a company that deals with the medical marijuana dispensation, for example, and you are an accountant, is that a problem?
Yeah. So yes, yes. So
the critical part, if you go to the question on the I-485 application, which has a good summary of what they expect you to answer no to, and it says, have you ever violated, attempted, or conspired to violate any controlled substance law or regulation of the United States or a foreign country? Conspired, okay, is the one here that we're talking about, to violate. So if you are working as an accountant in a place, it is easy to say, well, you have conspired.
Yeah, you've been involved in drug trafficking, which even though it's legal where you were, essentially, anybody working in that business, I think is, you can ask me about accountants. You can ask me about the guy working in the dispensary counter. You can ask me about their HR person. You can ask me about, the person running their website. And I'm going to say yes to all of those things because you are really kind of involved in the machinery of the drug trade in the eyes of the federal government. And that's kind of it on that front for me.
So now we go into this question that's really interesting that we were asked a couple times. Now there is a trading. There are there's large companies, massive companies in the business of medical marijuana, in the business of recreational marijuana, thousands of acres, thousands of employees working in these places, and some of them are publicly traded companies. Now, the question becomes, if I have a portfolio that includes one of these stocks, did I violate immigration law?
Well, Sam, even when you just say it that way, as the attorney in me just starts breaking it up. Well, there's like, what if you're invested in like a mutual fund that invests in these things versus, direct investment in a company, and there's distinctions to be made there as well. My first line of defense is avoid these things as much as you can, and my next line of defense is it's unclear as to how the government thinks about this. In immigration law, it's a funny thing. There's a lot of unanswered questions, and passive investment in a marijuana business or a drug-related business is something that is not determined whether or not it is problematic in the eyes of the government. I mean, one theory of it is to consider the issue of passive investment versus, active investment.
Exactly.
To one of the scenarios we talked about here during our streams previously is, the person buying the house to rent while they're on a non-immigrant status, H-1B, for example. Rules of the H-1B, you're supposed to be working for your H-1B employer. That's all can you do. Brian, can I buy a house and rent that? Yes, but it depends upon whether you're actively or passively involved in it. If you are, involved in that house, say going over there to fix the toilet, painting the walls, you get the idea. Maintaining the place.
And you hit the nail on the head, Brian. It's the active versus passive.
Yeah.
And I think there is a concurrence, an agreement among most attorneys that the active involvement in the production, in the sale, or the medical use of marijuana,
the business in general, yeah,
is an absolutely a prohibition. It will have a problem on you for you to become a permanent resident, and a problem for you to become a naturalized U.S. citizen. So an active investment is when you're taking action in a positive way. Now, if you are working there,
going in with a friend on their, hey, we're going to open a medical marijuana dispensary, and that's
like I say, you're a manager there. That would probably be active. I mean, if you are an accountant, we're going to have to argue whether that's active or passive. That's going to be an interesting discussion.
Well, if you're working inside the business, I think you'd have.
You think you're active?
I think, well, yes, but...
How about if you're in IT developing a database that has nothing to do with marijuana, has to do with the regulation of their electric system in the plant? Is that active or passive?
I'd say if it's...
I'm making it more difficult to say yes.
I would say that yes. I'd say if you're helping to keep the drug business, the illegal, in the eyes of the federal government, drug business going, I would avoid it. That's my bottom line.
Right, but is that active or passive?
It's active in my book.
It's one that people will argue one way or the other, and the government can go on the active side for sure.
Yeah.
Let's say you're given a program to develop, and it has to do with temperature regulations. Is that active? Is that passive? And you're working remotely. You've never been to that place. Is that active? Is that passive? That becomes a very debatable question.
Sure.
And you don't want to be caught in that because, number one, so people understand clearly, when we're saying active versus passive, we're not saying that passive involvement is okay. We're not saying that.
Yeah.
But we're saying clearly active involvement is not okay.
Yeah. And
right?
yeah, I mean...
Would that be a fair statement?
Yeah.
So that's settled law. There's nobody disagrees that if your involvement in the business is considered an active involvement, just like Brian said, painting the wall in the apartment or fixing that heater that broke down, that you become active, then your involvement, if it's active, that is definitely a problem for you to become a permanent resident or a U.S. citizen. Now, if the involvement is passive and the line between active and passive, as Brian and I were discussing, blurs sometimes, it's not clear, okay? But as you come out from that blur area, which, one officer may think is active, one officer may think is passive, that is something you don't want to be under the mercy of an officer's determination. But if you get into the passive area, okay, this is where some people are arguing whether this is okay, whether you're investing. So, and again, how passive, right?
Yeah.
Mutual funds, thousands of funds that go in and out. You don't even know. You're not even aware.
I'd say you have some pretty good, that's something, if somebody called my client on that, I'd be interested in taking on that case, how the heck, so I'm just, because I'm a foreign national,
So remote.
I'm just barred from all investment in
Right.
mutual funds in the United States,
Right. It's so remote that is absurd to even assert that. But
Yeah.
if you are just buying the stock and you know that you're buying the stock, now we're not saying that this is a situation where you will be barred from becoming a permanent resident or a U.S. citizen, but this is a situation where one officer is going to determine it one way if they knew, another officer is going to determine it another way, and this is a situation where there's no settled, the law is not settled in this area, and you definitely don't want to be one of those guys having to go through the grinder trying to figure out what's going on with the law.
Yeah.
So that's basically what we got on the marijuana use. I hope that is helpful for you guys on the discussion. With that, we can jump into some questions.
Yeah.
We have a visa bulletin update. Let's talk about the visa bulletin first.
Yeah, let's talk a little bit about the visa bulletin. So, I guess in as visa bulletins go, probably not terribly exciting. I have you executive summary of the changes here. So, on the final action dates, EB2 final action dates, the rest of the world moved from April 1st, 2022 to July 1st, 2022. So did Mexico and the Philippines. For EB3 China, again, this is final action dates, went from June of 2019 to September 2019, so that's good. More people getting their green cards filed. And the only change we saw on dates for filing was EB3 China going from September to November. But also, all these things point to at least, more availability in EB3 China, which is good for those folks, and more, I guess, less demand than anticipated at the end of the year for EB2 rest of the world.
So it's exciting. It's interesting because we always said that the government have not been doing any activities during the quarter to the other next quarter. We're saying, they're just really looking at them quarterly, mm-hmm. and now they surprise us.
Yeah.
They moved the rest of the world significantly for EB2. I
can see this though because they have a number of visas they have to get through this year, 197,000, right? And There's no next round of visas to be let out. There's no making sure that the rest of the world gets theirs before we push them down to EB2 or to other countries for the moving across the same category. They say we have 1 month left. We have X amount of visas to go. We're gonna approve them in the categories where they belong, and the last minute we'll allocate them, I guess, to cases we have that we can approve in other categories.
So what you're telling me is this movement for EB2, rest of the world, could be more of a strategic movement, not a calculation.
No, well,
because they're saying let's move it up, make sure that we're not missing any visas, and then we'll deal with it next year.
To get I suspect that movement has a legitimate basis in the need to move. We have more visas that we can use. Let's move this one last time, and we will get those visas out the door.
And looks like the worldwide employment-based preference is now out to the nearest single number.
Yeah.
197,091 cases, green cards.
I'd make sure they get those last 91 in.
Yes.
Sam, I have a bit of, I'm going to walk back everything I just said, and I'm going to be a little bit ridiculous. Why? Because how the heck is movement of the visa bulletin in the month of September? Sam, how long do you think it takes them to process an employment-based I-485? I'm just saying, moving that maybe if they have a case sitting on the shelf where the party date's not current, and bam, that will make it current. Great for that person. They'll get their green card in the month of September. But I can't imagine, somebody. I guess I'm not predicting that anybody's going to file their green card for the first time in September based upon this and get their green card within this fiscal year, obviously.
But I think they may have cases sitting.
Yeah,
that they can pull and approve.
There was surely somebody out there in the rest of the world category who had a
July 2022.
A June one, for example, because it only went to July 1st. But
April.
Yeah.
To April.
Yeah.
So April 2022, last year, I-140 approved and premium
Yeah.
processing. Yeah.
A priority date between
Yeah.
between April and July, who's just been staring at that darn visa bulletin saying, "Give me my green card."
And it's ready to go.
and for them,
And
I go
yeah.
clap, 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 and I guess we
Yeah.
stand a chance of getting those green cards.
Yeah.
And,
These will be mostly non-labor certification cases.
you can
Yeah.
you can file national interest waiver. Can you file national interest waiver with premium processing right now? I'm not sure. No, I don't think you can.
Well, in April 2022 and March 22 cases that have been filed and approved, they're ready to adjust.
Yeah.
So because the labor certification takes a year and a half, so by the time you get to it, the visa,
Yeah.
the
Yeah,
priority
yeah,
date
yeah.
backed up. So, but national interest waiver and EB1, rest of the world cases gets approved quick
Yeah.
and get the green card quickly. Those are the kind of cases will benefit from that movement.
Yeah.
Make sense?
Yeah.
All right. And like I said, 191 cases, 197,000 green cards worldwide for this year. And the more retrogression, obviously, no positive movement for India at any level in the EB3, in the final action date or the dates for filing.
Yeah. The last thing I'd say is obviously if folks aren't reading the end of the visa bulletin, that's where they always say some interesting things. And well, what they say about employment-based green card availability is, hey, we expect to run out sometime in September.
Yes.
Yeah.
And let's take your questions. This is when we tell you that we're going to give best we can to answer your questions based on information you give us, but don't rely on what we tell you because obviously we do not know enough about your case, and there's no attorney-client privilege is created because we're talking virtually on the internet. And lastly, please hire a competent immigration lawyer to help you with your case before you make a big decision on your case. With that, we're going to take the first question from...
A.K. Srivastava.
And that tells me that we should make the screen bigger
Yes.
so I can see it.
So,
Thank you.
A.K. Srivastava says, if I'm applying for a job in different states, whether the company will need me to physically be present and have an address there in the state before filing the LCI, or can they
LCA.
file the LCA prior to moving to that state? So, I guess the question is, do I have to live in a state before a company can file an LCA for me? The answer is,
So clarification, this is for an H-1B.
Yeah.
Somebody's on H-1B, and the timing of filing a document called Labor Condition Application with the U.S. Department of Labor, that has to be filed, and the question is when it should be filed.
yeah. And the answer is, it can be filed at any time. You're not required to live in the state where you are filing or an LCA is being filed on your behalf. Hypothetically, you could be, commuting to that state. For example, I've known people who have, spend the week at a client location and then go back to their home in another state entirely. It's a lot more common pre-pandemic, but yeah, there's no problem with that at all. Yeah.
All right.
Here we are. Let's check the next one. Part 2 from A.K. Srivastava. If I will do H-1B transfer in a different state, do I need to be physically present in that state prior to initiating the H-1B transfer? And that's another resounding no from me.
No, there is no requirement. I'm only thinking about the possibility that a person moving to another state and working remotely from home, and therefore must have a physical resident location to post the LCA. That's the only
Problem.
the only scenario that I can envision where movement is required. But if you're going to go and report to your an employer or a employer's client at their office, then absolutely there's not a requirement.
So to clarify a bit, so in case people aren't aware, in order to file an H-1B, a labor condition application for an H-1B, a posting notice must go up at the physical work site where you're going to be working. Now, we just said, it's not a problem, you're not living there, but somebody, I guess your point was that somebody has to be able to actually take care
There
of
has to be a place for a posting,
Yeah.
where the person will be physically working. So if you're working remotely from home and you have to relocate there, then that creates a timing issue a little bit. But if you're reporting to a client or reporting to a work site that's not your home, then there's no requirement to be present in that state prior to initiating the H-1B
Yeah, as long
transfer.
as there's somebody there to actually make that posting, as required.
Yeah.
Yeah, I review a lot of H-1B filings, and sometimes I see that people have relocated to the new location before filing that H-1B, change of employer or amendment, and sometimes I see that they haven't relocated yet. And honestly, neither really bothers me. It's either fine, this person's going to wait until the H-1B is filed or approved to move, or they already moved there in anticipation of the H-1B filing. Perfectly fine.
And the
with me.
physical posting requirement, by the way, is a remnants of long time ago mentality that hasn't changed. There's absolutely no need for it, but we do it. I mean, in the age of internet and electronics and communication via the World Wide Web, it doesn't make any sense, but we still have to do it. All right, let's take the next one, Brian.
Hi, Sam/Brian. Do you have any reference for current pending AOS cases being at USCIS or Department of State based upon employment-based applications? So,
Reference.
what's that?
What? I don't understand the question. Do you?
So yeah, I think Hari Guru is looking for a data source from the government that says how many pending green card cases that we have for employment-based, and I'm not 100% sure this is the answer to their question. I'm going to assume him. If you do a Google search, go to search for USCIS statistics. USCIS has a page, I believe it's called the USCIS Data Hub, right? And they post all sorts of reports there. And a recent one that we've talked about during this stream before is their I-140. It's their I-140 cases waiting on priority dates. And that report is out there. I'm not quite sure that's what Hari Guru is looking for because he says pending AOS cases. And when I see AOS cases, they do occasionally publish reports of how many cases we have in our inventory. And I'm pretty sure you're going to find that on the USCIS Data Hub as well. But the really good data that we got, at the end of last year, I think it was, or maybe
it's from litigation.
It was from litigation where
it's not something that they publish regularly.
Yeah.
They don't like to give you information when information is not required by law or mandated by a judge, because more information you have, the more questions you're going to ask, and they're not interested in. I mean, they're overwhelmed. I'm not justifying their action, but they don't want to answer it. So, Himanshu, I have dependent 485 adjustment applications. The primary application is pending. After 180 days, do the 485 portability rule apply to dependents, or is the dependents applications always tied to the primary application? It's an excellent question.
Yeah, it's a really good one.
Very good one. And the 180-day only is related to the primary petitioner or the employee. And the family members really hang on that application. So the requirement that 180 days have to pass before you can move to a different employer only applies. So if you, for example, on day 175, you have applied and able to apply for all the family adjustments, on day 181 you can move to a new employer and all the family goes with you. They don't have to wait 180 days. Do you agree? The 180-day portability rule only applies to the primary applicant. And to be clear, if the family members, get that, everybody gets their EAD after, 60 days. Well, congratulations, family members. You can, if you want to abandon your current non-immigrant status, you can go ahead and work, wherever you want with those EADs. They are not bound by the portability rules. Yeah. So we're being asked, what are your thoughts on the nearly 70 Indian nationals suing the U.S. government for denying their visas because of alleged fraud perpetrated by their employer? That's a very interesting question, and it's well, I mean, what do I think? It's about time.
Sure. I don't know. My little attorney brain goes immediately towards the question of standing. Whether they have the standing to
I think they can assert standing.
Yeah.
Oh yeah, because they're damaged.
Injured. Yeah.
Oh,
yeah,
they're injured.
They've been injured, but it's not something they're entitled to. It's the selection is owned by the employer. The process is the employer.
That's the government's argument.
Yeah.
And the employee's argument
Now, Sam, I realized I've committed a terrible crime upon our audience. I brought up the legal issue of standing
That's right.
here.
That's right. So yeah, we thank you for saving me from responding.
Yeah, I almost dragged you down with me.
Yes, good.
So I guess I would say, to put it a little bit simpler, there's some legal issues there, and those cases will be fun. Fun to watch. I mean, fun, interesting for us attorneys to watch. What do you think of very broadly of their potential for success?
Well, I mean, these cases are incredibly geopolitical in nature.
That's very true.
When it comes to the judge, their background, their energy, their interest, who they are, So it's and also the facts. I mean, if these guys, for example, have spent a long time here in the U.S., if they're highly educated, distinguished in their achievements, it will make a lot better cases. But if these guys graduated from mediocre schools, they'll make a less impressive case. It all depends on, these cases, it's 20% law, it's 20% law, 80% everything else when it comes to the decision.
Well, good facts are always good. Bad law usually gets made out of bad facts.
Yeah. So, I mean, I would be interested to see what's going to happen to that decision.
I mean, my general instinct on fighting the government is odds are you're gonna lose before if you ever win you're gonna lose before you win.
So with the conservative mindset, you may find a little bit more relief, honestly, in some of these things. That if they find that there is some, they have to look at it from an original interpretation standpoint. Yeah. So it'll be interesting to see, and always whether it goes to appeal, and so forth. So Ricardo Foster.
Yeah, who worked for these other companies that
Aztec Technology, Integrated Technology, and Wire Class Technology. Yeah.
Yeah.
So this is very interesting. Yeah. Thank you for the information. All right. Viraj K. I want to move to Canada on open work permit. However, I need to visit the U.S. for medical treatment. Can I apply for B1, B2 in Canada, H1 visa stamped until 2025? Will impact stamp I-140 approval. Okay, so this gentleman is applying for a work permit in Canada.
It's a very dense question here.
No, but that's a good one.
Yeah, sure.
He has medical need and has an H1B at the present time and would like to come to the U.S. for treatment, for medical treatment. So this case really distills itself to the question is, how can I come to the United States for medical treatment? And because I'm going to be abroad. Yeah. And what is the impact on my H1B stamp? Really, this case.
Okay, all right. I'll take. I have a different take on it, but
go ahead.
Oh, for me, I think of issues. Where can I get stamped? And is that I-140 approval, the last thing that's in there, going to affect my ability to get a visitor visa stamp at all? And my answers to those are simply, well, anywhere. Usually, the U.S. government will allow you to go for stamping anywhere where you're legally present. Meaning, if you're going to be in Canada on a work permit, I presume you're going to be in a legal status in Canada, meaning you should be able to, apply for a visa to the United States there. That I-140 approval, in theory, could impact your eligibility for a B visa. B visas have a requirement that you have no immigrant intent, and that I-140 is arguably showing immigrant intent.
So that's a good answer. So for me, I agree with everything you said, but I will add a little bit more to it, at least the way I think. A lot of these cases really are, again, half law, half facts.
Sure. And
the law is you have an I-140, right? You have an I-140, and you, it's an immigrant intent. But the question of the medical treatment and the details of it dictates the answer, honestly. So if you can show that there's no comparable medical treatment in Canada, which is going to be difficult to show, to be honest with you, and you're coming to the United States for medical treatment because of maybe there's a unique program that you need,
not you're trying to take care of the employer's health care. You know, on an H-1B, right?
Okay, yeah,
I'm just building some facts.
Yeah, sure.
So those things will drive the answer more so than the AB1 and the H-1B and so forth. You walk into that consulate with a letter from a doctor that says this treatment is not available in Canada, or it is delayed 6 years to get it, and is immediately available in the U.S., showing financial ability to pay, and I think, and showing that there's a dire need for it.
Yeah.
I think you're going to get your
Oh,
B
yeah.
visa.
I don't think that I-140 is problematic. You just, I mean, again, you're coming on a different, to be understood though, you're coming on a different visa than an H-1B visa though, and you have different requirements. And you got to, again, convince them that I'm coming strictly on a temporary basis for that medical treatment.
Yeah. So, I mean, it's based on the facts of the case, honestly, the answer. And that's where the lawyering comes into part in preparing the presentation that can support your position, if possible.
Yeah.
All right. So we got Emily Marshall for you, Brian.
Yes. So if the EB3 Rest of World filing chart becomes current in October, how long do you think the final action date for the entire category to become current? You know, this is when I try to answer that question by looking at some data, and I think we still have it here saved on the computer. Here it is. You know, you may be able to figure this out in a more logical way. What I have up in front of me, I can't easily share it, is that I-140 backlog chart that I mentioned earlier. It shows, based upon certain categories, what the backlog is. So for the rest of the world, the EB3 backlog is stated as of when was this? As of March, I think it was, as to be 11,829, and that's not that big a backlog as the bottom line for me. And I think it's reasonably possible that EB3 rest of the world gets pretty close to current immediately.
Mm-hmm.
Yeah.
All right. Good analysis, Brian. Thank you for that. So we go on to the next question.
Yeah.
And it is from
Talk to San, a frequent viewer,
Dr.
as I
San.
recall.
My EB2 priority date is 2012 November. Will the final action date move to 2013 in October visa bulletin? Well, all right.
We will entertain the question.
So the final action date
for EB2
for EB2 India is 2011 January right now.
Yeah.
And is there going to be a 2-year movement?
Well, Sam, I'm gonna skip the final action dates and go right to the dates for filing. That's the projection, and dates for filing says EB2 India May of 2012 on the September visa bulletin, which again the dates for filing are forward-looking. What do you think?
It will not get to November 2012.
It doesn't. If the Department of State is being honest about what the purpose of the dates for filing is, I'm inclined to agree with you. It seems like it will get close. Maybe not. Maybe not this coming fiscal year, but the one after it seems to be a lot more likely if the.
Unless there is new legislation, and we talked last week about the chances of new regulations coming down the pipeline is not very promising right now.
And there's that letter from the 50 or so Congress people who are pushing the president to make a change on that front. But again, we had this conversation maybe about a month ago. What are the odds of visa reform?
And last week, and we figured it's maybe 1 in 5. 20% chance?
Yeah, in the next 2 years low, in the next 5 years higher.
More than 50% chance.
Yeah, it seems it's hard not to be a little bit optimistic on that front, because as we discussed in the past, I mean, going back to late 2021, we were sitting here going, we're so darn close to this. There's 2 votes away from the reconciliation bill that would have made a massive change in visa availability, and it was screwed up by Kirsten Sinema and Joe Manchin. I can remember their names this time.
Who is seriously considering for running for President of the United States. That's not good news for us.
Which one? Joe Manchin?
Joe Manchin, as an independent.
Oh, boy. Yeah. So I guess we get a minor talk about U.S. politics. Is independents tend to split the vote, and
He will not. He will probably not get as much. He will probably get more Republican than Democrats on his side.
Yeah, he is. I'd say he's probably as far right as the Democrats get. But if he, I mean, I imagine his fantasy is that all I have to do is just take the middle from myself, and then it's President Joe Manchin.
Wouldn't it be great to get a brand new president that's not a Biden and that's not a Trump?
Yeah.
Wouldn't that be great?
I am not looking
to get somebody new with new ideas.
Well, Sam, I am not looking for. I mean, we're coming into the fall, and that means will put us a year away from the next presidential election, which means we are going to be entering in the official political rodeo,
which is zero immigration reform for that year.
Yeah, yeah. They throw around immigration like it's a dirty word, and
everybody's shy. Everybody's afraid
to
support immigration. They don't want to lose vote. But with that. I think we may have answered everybody's question. I'm very proud, unless there's some question that just.
Looks like we had a couple pop-ups here.
Okay, we'll throw them in before we conclude for the day.
Yeah.
Viraj K. I have a compelling circumstance employment authorization document approved until June 2023 due to chronic medical condition disability, and I was taking treatment at the Cleveland Clinic.
Oh.
And have a specialist there. Okay.
Compelling circumstances EAD, a rare EAD.
Probably a part two to that.
Well, I think that was his answer, because he was asking about the travel back and forth from.
Okay, this is excellent. So factual grounds. So I mean, obviously, access to the Cleveland Clinic is very special because it's one of the most renowned institutions in the world, and perhaps the doctor who is familiar with your condition. Can write a letter that says, being familiar with it and continuing the same treatment is critical for his improvement, and starting with a new facility and a new doctor may negatively impact perhaps, or something like that.
For me, that sounds like a viable visitor visa application, which again, as long as you're legally allowed to reside in Canada, the U.S. consulate will usually allow you to get your stamping there. And
some doctors have excellent handwriting and they write amazing letters, and some doctors are very bad at it. So assuming Cleveland Clinic, these are superhero doctors usually, and they're very caring and they're at the cutting edge of medical science. I'm assuming that they will be able to write a nice letter for you, and you might want to give them the key words. I'm looking for words like negative impact on my treatment. If I get, alternative doctor, a program, something to show the need to come in and to continue the treatment.
Give them a draft. Give them a file they can work with and customize to their heart's content. Yeah.
Yes. All right, Brian. Do we have anything else before we conclude for the day?
There's one last question.
All right, let's take it. Why not?
Yeah.
Can you please explain what is the Cronin memo? I am on H-1B valid until mid-2025, have an adjustment status EAD AP. If I travel and return to the United States on AP, can I continue to work on H-1? Can employer file extension? So I'm assuming, number one, the Cronin memo obviously is a memo.
That's the 20-year-old memo, right?
I'm assuming because it's people who Cronin is the author usually.
This is the one, the dual intent.
And this is a 2010.
May 25th, 2000.
2000. Oh my God.
Yeah, this is the one. This is the one where we talk about it on here.
As old as some of the religious books out there.
For those who want to follow along, just Google the Michael Cronin memo, and odds are you're going to find a PDF of it. Yeah.
Okay, so this is a FAQ that was written by Michael Cronin in 2000 and talked about a lot of things.
Yeah.
And the thing that's talked about that everybody uses or refers to is the ability to switch from an advanced parole to an H-1B.
Yeah.
And it was kind of written in a narrow context in which is expanded, and there is a clear, informal, undocumented acceptance of this policy until today.
Yeah.
With USCIS.
And if people ever thought it was easy being an immigration lawyer, this is the stuff we have to deal with. There's no. I mean, there's a book we read, but it's full of like a patchwork of policies that USCIS could overturn at any day if the mood chooses them. you know.
And it's page, the H-1B is page 2, item 3, and I have it here on the screen.
Yeah.
And I wish I can share with you. It's not that easy.
Yeah.
Because we have it set up. We didn't set it up
Yeah.
to share. And the question is, if an H-1 or an L-1 non-immigrant has traveled abroad and was paroled into the United States via advanced parole, the alien accordingly is in parole status.
Sure.
Does this rule allow that person to apply for an extension of non-immigrant status? And the answer is, until we tell you later,
Yeah.
until we give you more details in the future, which they haven't, you can apply for an extension of status if you come into the United States and I think you join the H-1B employer,
Yeah.
if that's what I remember.
Yeah. How does, yeah.
So so let's go back to the question specifically asked by HF. If I travel and return to the US on advanced parole, can I continue to work on H?
H1, yeah.
Can employer file an extension or a transfer? So the memo, Brian,
Yeah.
it contemplated somebody coming back without an EAD.
Yeah.
And in a
Scenario where you leave the United States, you're on H-1B status, you leave the United States, you use your advanced parole to come in, you're a parolee, and oops, I have separate advanced parole and EAD. They gave me the advanced parole very quickly. I don't have an EAD yet, which is very funny in today's world, an fathomable concept, but yeah.
So, and they said, yes, they can apply, you can join the employer without even an EAD.
So they'll honor your
You
H1.
would not be deemed to have violated your status because you have this H-1B, and then you can extend your H-1B.
Yeah.
Now, the red herring potentially is you don't have an EAD, but I think that's been overlooked. So whether or not you have an EAD, that policy still extends until today, the way we've seen it being applied, that you could join the H-1B employer and you can extend your H-1B if you join your employer.
Yeah.
And extend your H-1B doesn't mean you extend your H-1B with the same employer necessarily. You can join this employer and file an H-1B transfer right away to a different employer.
The policy talks about returning to the same employer.
Well, you can join the same employer, but the first H-1B filing could be with another company.
Yeah.
Because it's an extension of an H-1B.
I've got
it doesn't
you.
have to be with the same employer.
Yeah.
Yeah.
And well, does it? I don't know. USCIS doesn't tell us.
Well, I've seen it being approved that way.
Oh yeah, I've seen. So I guess that's the point I was trying to get towards. I've seen a lot of interesting variations on this scenario get approved, and people ask, is XYZ possible? And the answer is, well, not 100% clear per the policy, but if you file that, I think there's a reasonable chance that it will get approved, because only does the individual officer who's reviewing your case know what they think USCIS policy is.
Yeah. So HF continues to part 2. Once back to the U.S. on advanced parole, how can I switch to H1, and how quickly do I need to do it? Would travel to Mexico and return to the U.S. using visa revalidation puts me back on H1B? So that's part 2. Subpart A and subpart B, because these are two different questions and very distinct and complex and different. So let's take the first part, Brian.
Yeah, well, I'll address part 1. There's no time frame on when you need to do it. As I read the policy, they contemplate, you coming back on your advanced parole. We'll still honor your current H-1B work authorization until its very end, and basically, instead of just letting go of your H-1B, if you file an H-1B before your H-1B approval ends, you extend it at the end. So there's no time limit. How about saying if you just let your H-1B approval lapse, and you come back, let's say you have 3 months, you come back on advanced parole, you have 3 months left on your H-1B, right? You wait 4, 5, 6 months to file that H-1B, that new H-1B to get back on. You go on the EAD
Yeah, I don't think you can. My reading of the regulations, I don't think you can do that.
I don't think you can. I think you have a fundamental problem in that you're out there using the
It's not an extension anymore.
EAD. Yeah, it's not.
Not an extension. Now, do you have to use a visa revalidation? No, you don't. And that's kind of mixing up a little bit two different concepts. The visa revalidation is not necessary for you to get back on H-1B and join the employer. It's there. I mean, you don't have to do that. All what you have to do is just join the employer, and you're not deemed to be on H-1B I think we agreed to that in
Yes,
prior
for
discussions.
sure. Yeah, you're a parolee. That's
You're
what the
still a
policy says.
parolee, but when you file the extension, and you file it whenever you're ready, there's no rush to do that as long as as your current H-1B is valid.
Yeah.
But you have to do it during the validity period of the H-1B.
Sure.
And you file for the extension, and once that extension is approved, it comes with an I-94, and the approval of this H-1B becomes the grant of the non-immigrant status, puts you back in a non-immigrant status, and that's really the only scenario by policy that you can get back on the non-immigrant from an advanced parole.
If by policy that though is what they're willing to approve won't necessarily align with what policy.
But we haven't seen a lot of pushback on that.
Yeah,
we really have not.
Exactly, I fully agree. Now the question of automatic visa revalidation, it's been a while since I've read the automatic visa revalidation policy, but as I recall, it requires you to be in status at the time you leave the United States, and if you're there as a parolee, you are not.
But there's no need to use the visa
sure.
revalidation to get back on H-1B under the scenario.
Sure.
You just file for an extension. You don't have to leave and come back. It's just not necessary. Because you come back you on the I-797 and you have to be in status. And that's also loosely interpreted.
Well, yes, no doubt. I mean, during this very stream, we've heard people tell us, like, I went to the border without status, and they came back, and Customs was happy to give me a.
And I've seen the opposites.
Yeah,
I've seen the opposite.
I saw them. I think my perception of that situation is they eventually started to not do that, and turning people away from automatic visa revalidation.
Yeah.
Yeah.
So I've had a client. This is like 20 years ago when the visa revalidation was on the books, but was not used and not talked about. And I armed him with the law and the regulation and the letter, and he had to leave for emergency travel to Mexico. He's Mexican.
Sure.
And was on H-1B, I think, or was on E-visa, I think it was E-visa. I don't remember. But anyways, he went back.
I think I know who this is, yeah.
And then flew back in. And in Detroit, they looked and they say, visa reval what? And they looked at each other, and he described to me the whole thing.
Where was he calling from you? Calling you from when he was describing this to you, huh?
It was late at night. There was nobody coming in. There was one flight, and there's too many officers. He said they put that letter on the table, and there's like 6 or 7. That's when you know you're in trouble. Yeah. 6 or 7 officers staring at the letter, completely confused. They put him on the plane next morning and sent him back.
Yeah, I figured that call was going to be from Mexico.
And then we had him cross one more time from the Mexican border. And they let him.
Yeah, I mean, it's a funny little thing about our practice. The individual officers out there have so much power, and it can be real problematic if somebody makes a not great decision on your case outside the law. Yeah. Suddenly, you're the one paying the cost of it. Like for that example, paying for the cost of another flight back to the United States, and just rolling the dice as to whether or not you're.
Well, I mean, his dad. He said, "My dad is sick," and I said, "He said I gotta go." I said, "Okay, visa revalidation." He said, "Okay, I must see my dad. He's sick. He may not live for more than 2 weeks." And he took off. Yeah. He had to do what he had to do. Yeah. Talk to Sen. My advanced parole is expiring in October and filed extension in April, but so far I have not received any approval. Surprise. What should I do if my advanced parole is not approved before it expired? Just stay in the country and don't leave. I mean, assuming if you're on an H-1B, you're fine to leave, but if you're not on an H-1B visa, do not leave the country until it's approved.
Yeah, I would fully agree with that. If you have an emergency, USCIS does, with reasonable documentation, fairly freely give out emergency advance paroles, but it's a different process.
And the standard is very high. I mean, they want to see a letter that somebody's on their deathbed or something.
The last one I did was, it was a sad one. It was her father was dying, and by the time they got around to bringing her in for an appointment, her father had passed. It became more of a, I'm going to see my family because my father died, not because I can't see my father die. That's upsetting.
Yeah. So remember, the emergency advance parole is always a resort in a situation you have to travel in an emergency. With that, Brian, we conclude today's presentation. Thank you guys for listening to us. Until next Monday, 6 o'clock, you guys have a great week.